I'm sure you've heard about this one. It made national news when the arrest first happened. The Jupiter, Florida parents who are currently accused of locking their adopted teenage son in an 8-by-8-foot box that they kept in their garage. The child had nothing else in that box other than a bucket. Now, these parents, wait till you hear this one. This is the next big shocking thing. They want some evidence thrown out in their case because they're claiming that their minor children hacked into their email and social media accounts and obtained it and turned it over to the guardian ad litem who is trying to legally protect those children. So now this couple's attorney is fighting to have the information thrown out and a protective order issued against the minor kids. WPTV's Ryan Hughes has the latest developments from the Palm Beach County Courthouse.
Timothy Ferreter was not in court for a quick hearing. His attorney spoke via Zoom. She filed a protective order and claims that evidence was obtained illegally after her client's email was hacked.
In a new 7-page filing, Timothy Ferreter's attorney alleges her client's and his wife's personal Google account was hacked by one or more of their children. The filing says, quote, the minor children were never given the login credentials to access the subject Google account. The motion also says the information obtained during the hack was sent to an attorney with the Foster Children's Project Legal Aid. We tried speaking with Timothy and Tracy Ferreter, but no one answered the door at their home in Jupiter Thursday. The couple is charged with false imprisonment and aggravated child abuse. Police say they kept their 14-year-old son locked in a box inside their garage for hours at a time, and he was only allowed out to go to school. Ferreter's attorney writes in the filing the documents illegally obtained by the children must be supplied to the defense, and the lawyer should be required to withdraw as attorney ad litem. The couple's 4 children remain in foster care.
And we reached out to both Ferreter's attorney and the Foster Children's Project for more information, but have not heard back. A motion hearing is now set for April 13th.
Oh, we're going to keep our eyes on the outcome of that one. This makes me sick. Let me bring in my guests. We have 2 great guests on the program today. They're both criminal defense attorneys and former prosecutors, Joe Tamburino and Josh Ritter. Okay, let's start with the allegation. So they're making this allegation that the kids did not have the login credentials to go into email or social media accounts, and they're calling it a hack. Joe Tamburino, I want you to do me a favor and take the position defending the kids. How do we even know this was a hack?
Exactly. 3 things you can defend the kids with. Number 1, all we have to believe is you, Federers, so we don't have to do that. There's no physical evidence of that. Number 2, the kids were common users of the computers. These are family computers. Whether or not you have a separate password on your account is meaningless. They're commonly used computers. Number 3, and this is more of an equitable defense, they're kids. Of course, they're going to go through computers. If a kid sees something, a new gadget, a new device, you want to check out something on the internet, it's going to happen. This will lose.
Yes, bravo to those smart kiddos. I would love to know what those kids found that they turned over to their lawyer that now the Ferreters want to so badly keep out of this case. Josh Ritter, let me tap into your experience as a prosecuting attorney. Wouldn't law enforcement have arguably found it anyway?
Perhaps. I mean, one of the things we have to understand is that the landscape of the law as it refers to electronic devices is really changing a lot. The Supreme Court has come out with decisions recently that view electronic devices differently than it ever had in the past, and there's a lot of protections that come along with this. And I understand the arguments that, hey, listen, it was a computer inside the house used by everybody, but people's passwords and people's electronic information now contain every aspect of their lives, so we can understand at least why their defense attorneys might be making those arguments. Listen, I think we all clearly don't take the position of defending this couple and what they did to the child here, but from a purely scholarly point of view, as far as electronic evidence, I could see that they might have some feet to stand on in their defenses here.
Right, Josh. You know, and they cite several different laws. They're claiming that it's a violation of Florida law. They actually cite the Wiretap Act in Florida. And everybody on this program knows those types of laws are not easy to read or understand. I know, speaking from experience in my former office, we had a whole unit that was designated for that. Anytime a case involved some kind of a wiretap issue, there were attorneys who did that all day long and were kind of our in-office experts. So they're citing that. They're citing another state law that has to do with accessing the computer. And what they're upset about is that the children obtained whatever information it was and turned it over to their guardian ad litem. Joe Tamburino, let me ask you, one of the things they're requesting in this filing is to have that attorney withdraw from the case and also produce everything that was turned over to her. How do you think the judge might come down on this, and why, please?
He will deny removing the attorney, and of course he will say you got to give the defense what you found. That's just pure discovery. I mean, that's going to come out anyway. Just like you mentioned before, Julie, we have no idea if they did search warrants on the case and found this information anyway. But the judge will clearly say no, you're not going to remove the attorney, and through the discovery process, the defense will get this. And also, we got a little bit of a pot and kettle thing, because the Federers, basically what they did, they too, it seems, broke the wiretap law, allegedly, because we have information that they were recording other kids, students, without those individuals' permission. So got a little bit of a pot kettle thing with what they're doing here.
Oh, that's a great point too, Joe. And we know one of the big pieces of evidence with this, Josh, is that there was said to be a camera that was positioned above that 8-by-8-foot box that was said to be in the garage. Remember, this is Florida. Can't imagine the temperature in that garage was anything comfortable, and that poor child allegedly locked in that box for as lengthy as a period of 18 hours time, only let out to go to school or to do chores around the house. So here, you know, as far as the evidence in the case, if there's a video that law enforcement has, and they say they do, of that child locked in there, you know, I don't know what difference keeping out whatever was found in the emails or, you know, anywhere else might have to do with the case. I keep thinking, is it something to build another case? Of course, my mind went to something really sinister. Don't know, so I don't want to speculate, but share with me your thoughts on the case evidence and just proving the child abuse allegations that we know are filed.
No, I agree with you. It sounds like they're very concerned with whatever was found on those computers, but it could also be one of those situations where their defense attorneys are just in this unenviable position. I mean, it sounds like there's a lot of very convincing evidence. Not only will you have the children testify, I imagine, to what they witnessed taking place, but now you've got videotape capturing the crime as it's taking place. I don't think they have a lot to work here. So it's one of those defenses where you're just trying to attack where you can. You know, death by 1,000 cuts. Wherever you can make a little bit of headway is doing the best that you can in just trying to protect your clients. But it looks like it's a insurmountable case from what I've seen so far.
Right, Josh. Joe, tell me, do you see this case going to trial, or do you think we might see some kind of a resolution prior to that point?
Resolution, because the risks are too large. I mean, you go to trial and lose on this, the judge is going to give you the maximum. There's no doubt about it, because, no matter who you are, whenever you get a case that involves child abuse, specifically this extent of child abuse, nobody likes it. I mean, think about how you're going to pick a jury for this. I mean, where are you going to get 12 people to say, well, yeah, I could deal with some of this? It's never going to happen. I mean, this is just such an egregious case. So, of course, they're going to try to resolve it.
Right, Joe. And these Fereders, by the way, adopted that child who's said to be the victim on this case. Just truly sickening allegations. We've got our eyes closely on this one. We will be watching the outcome when this hearing happens in April. I believe the 13th is the date.